to give us a quick comment arising out of the issues that were raised on the floor.
Well, in brief, the first of the questions and observations interested me particularly is it strikes me there, as enthusiastic as we may be about anti-corruption initiatives, there are two dangers of which we must be particularly mindful. The first is what you described as the witch hunt phenomenon. The danger there perhaps is as great, if you will, and how we balance that in the judicial system, but particularly through responsible media, is going to be a real test of our societies. The second one is a more commercial view. That is the danger, if you will, of introducing greater bureaucracy and inefficiency. Some would argue that some aspects of the Foreign Corrupt Practices Act, some would argue that the UK anti-bribery law have in some ways introduced greater inefficiencies in the conduct of business. How we balance, if you will, our efforts to fight corruption with, on the one hand, political responsibility, and secondly, on the other hand, enhanced efficiency in terms of greater prosperity for the citizens of our countries, is going to be the balance, I think, in which our anti-corruption efforts ultimately will be judged, in addition to the way in which it affects the rule of law.
Deputy Chief Justice.
Well, all these questions that have been raised so far are very interesting. I just like myself to cover them if I may comments. Perhaps the first the globalization of anti-corruption norms, and what those norms would be if we are in the international councils about them. Well, at this very specific area, I mean, we should really look at corruption, not only as a societal or commercial economic phenomenon, but rather as a legal one as well. And at the international legal level, those of us who have been involved in private international law, for example, know very well that the aim of this private international law is not to have uniform legal systems as on the day, because every country, every legal tradition has its own arrangements and its own legal environment and its own understanding of the law, and therefore it might not be that easy to reach consensus in different controversial issues at the legal level. Therefore, the aim would always be sort of really getting into dialogue and try to accommodate those different legal perspectives at the same umbrella. So we know we're different, but we do appreciate each other and understand each other and are willing to cooperate with each other. But today, this is not the case when we're talking about anti-corruption, because I believe we have moved a step forward. And we are aiming at having this sort of global norms that all of us will accept. And those norms, I mean, if we are to give an example, we cannot give a concrete example, but we would give just a few general ones. Perhaps transparency in this process, and also sort of a combination of procedure as well as substantive norms that should be really upheld in order to have this process established at the international level. So a concept of fair trial, for example, as a procedure level, and what is how to encounter corruption, how to deal with the case as a criminal level, and also from the other perspective, the social level, how a given country would really address this phenomenon. How do we really change the behavior and attitude of the people toward this? How can we really promote their understanding about the dangers of these activities and what harm they should cause to a society? Those are basically the basic norms that should be included within these processes. Well, on the other hand, I was very much struck earlier by the comment that was made about those actors who really are responsible for the corruption activities. And apparently, the commentator posed the question, competitivization, then he provide us with an answer later on. So if when he sat and the legislature itself is correct, how it encounters us. But as you correctly said, under the law, if we have a sort of a separation of power, the Constitution principle being established within a specific jurisdiction, this would help to perhaps a practice of judicial review of constitutional issues. This would help really the judiciary to strike the balance and really strike down whatever legal activities that are in conflict with the Constitution. At the end of the day, we would have the rule of law.